that you may consider the defendant's mental condition at the time of the killing, including any credible evidence of mental impairment or the effect on the defendant of her consumption of prescription drugs, in determining any of the elements in the murder and the second-degree charge as well. I mentioned that for some of the others, but specifically for the charge in murder of second degree, there's an element regarding intent. Okay, so I just kind of wanted to make that clear. Probably is suggested in that, but as I read through it, I just kind of wanted to remind you that you can, as I said, you can consider the defendant's mental condition at the time of the killing, including any credible evidence of mental impairment or the effect on the defendant of her consumption of prescription drugs, in determining the elements in murder in the second degree. All right, so I hope that cleared things up rather than confusing you any. But now I'm going to go to the general principles in regards to this case. All right. Now, as I said to you before, I'm incorporating the instructions that I gave earlier before the closing arguments with these instructions. So I want to talk about the presumption of innocence and the burden of proof. Once again, the indictments against Ms. Clancy are only an accusation. They're not evidence. The defendant has denied that she's guilty of the crimes charged in these indictments. The law presumes the defendant to be innocent of the charges against her. This presumption of innocence is a rule of law that compels you to find the defendant not guilty unless and until the Commonwealth produces evidence from whatever source that proves that the defendant is guilty beyond a reasonable doubt. This burden of proof never shifts. The defendant is not required to call any witnesses or produce any evidence, since she is presumed to be innocent. The presumption of innocence stays with the defendant unless and until the evidence convinces you unanimously as a jury that the defendant is guilty beyond a reasonable doubt. It requires you to find the defendant not guilty unless her guilt has been proved beyond a reasonable doubt. Your verdict, whether it is guilty or not guilty, must be unanimous. All right. Now, reasonable doubt. The burden is on the Commonwealth to prove beyond a reasonable doubt that the defendant is guilty of the charges made against her, as I just told you. But what is proof beyond a reasonable doubt? Well, the term is often used and probably pretty well understood, though it's not easily defined. Proof beyond a reasonable doubt does not mean proof beyond all possible doubt, for everything in the lives of human beings is open to some possible or imaginary doubt. A charge is proved beyond a reasonable doubt if, after you've compared and considered all of the evidence, you have in your minds an abiding conviction to a moral certainty that the charge is true. When we refer to moral certainty, we mean the highest degree of certainty possible in matters relating to human affairs, based solely on the evidence that has been put before you in this case. I've told you that every person is presumed to be innocent until she is proved guilty, and that the burden of proof is on the prosecutor. If you evaluate all the evidence and you still have a reasonable doubt remaining, the defendant is entitled to the benefit of that doubt and must be acquitted. It is not enough for the Commonwealth to establish a probability, even a strong probability, that the defendant is more likely to be guilty than not guilty. That is not enough. Instead, the evidence must convince you of the defendant's guilt to a reasonable and moral certainty, a certainty that convinces your understanding and satisfies your reason and judgment as jurors who are sworn to act conscientiously on the evidence. This is what we mean by proof beyond a reasonable doubt. Now, I want to talk initially about my function of the judge. My function as a judge in this case has been to see that the trial was conducted fairly, efficiently, and in an orderly manner. It's also my responsibility to rule on what you may consider as evidence and to instruct you on the law that applies in this case. It's your duty as jurors in this case to accept the law as I stated to you. You should consider all of my instructions as a whole. You may not ignore any instruction or give special attention to any one instruction. You must follow the law as I give it to you, whether you agree with it or not. That's not just because I'm the judge. It's because every person who comes to court for trial is equal and is subject to the same law. And if jurors in each case were to apply what they thought the law should be and the jurors in different cases had different views, then the parties in those cases would not be treated equally. The law that I'm instructing you on is the law that has been established by our legislature and our appellate courts, and it applies to everyone. And you must apply the law as I instruct you. Function of the jury. Your function is to determine the facts of this case. You are the sole and exclusive judges of the facts. You alone determine what evidence to accept, how important any evidence is that you do accept, and what conclusions to draw from all the evidence. You must apply the law as I give it to you, to the facts as you determine them to be, in order to decide whether the Commonwealth has proven its case. You should determine the facts solely on a fair consideration of the evidence. You are to be completely fair and impartial, and you are not to be swayed by prejudice, by personal likes or dislikes towards either side, or by any personal view you may have the nature of the claims or the defenses in the case. Your decisions must rest solely on the facts that you find and the law that I give to you in these instructions. Nor are you to be influenced by any personal likes or dislikes you've come to feel towards any party or any attorney. In this courtroom, every person is equal and is entitled to a fair and impartial verdict in accordance with the evidence and the law. You are not to decide this case based on anything you may have read or heard outside of this courtroom. That, with the exception of that, is the observations you made at that view, and I'll talk about that a little bit later. You are not to engage in any guesswork about any unanswered questions that remain in your mind, or to speculate about what the quote-unquote real facts might or might not have been, beyond what has been proved by the evidence. You should not consider anything that I've said or done during the trial as any indication of any opinions as to how you should decide this case. If you believe that I've expressed or hinted at any opinion about the facts of this case, please disregard it. I have no opinion about the facts or what your verdict ought to be. That is solely and exclusively your duty and your responsibility. Now, I'll talk about function of counsel. It was the duty of the lawyers in this case to object when the other side offered evidence which that lawyer believed was not admissible under our law. They also had an obligation to ask to speak to me at the sidebar about questions of law, which the law requires me to rule on outside of your hearing. The purpose of such objections in rulings is not to keep relevant information from you. You should not draw any inference, favorable or unfavorable, to any attorney or their client for objecting to proposed evidence or asking me to make such rulings. That is the function and responsibility of the attorneys in this case. Now, what is evidence? As I told you, you are to decide what the facts are solely from the evidence admitted in this case and not from suspicion or conjecture. The evidence consists of the testimony of witnesses as you recall it, and any documents, photographs, or videos or other things that were received into evidence as exhibits. You may also consider any observations that you made while at the view that we took earlier in the trial. In this case, there may be certain documents or photographs that are entered multiple times. This does not mean that that evidence is any more or less important than any other evidence. You, the jurors, will decide how to evaluate the evidence, that is, what weight to put to it. Now, in reviewing documents and evidence, you might find that there's some information that's been whited out or redacted. This is because the court has made some legal rulings about what evidence is relevant to this case. You should not draw any negative inference against either party based on these redactions, nor are you to speculate about what information has been redacted. In addition, a couple of stipulations were entered into evidence during the course of this trial. A stipulation is an agreement that has been made between the parties. The contents of such stipulation may be accepted by you as facts and relied on you along with other facts that you find based on the evidence. Now, of course, the quality or strength of the proof is not determined by the sheer volume of evidence or the number of witnesses or exhibits. It's the weight of the evidence, its strength, intending to prove the issue at stake that's important. Some things that occur during a trial are not evidence, and you may not consider them as evidence in deciding the facts of this case. A question put to a witness is never evidence. Only the answers are evidence. So if a witness agrees with a fact or a proposition contained in a question, then the fact or proposition agreed to is evidence. However, if a witness disagrees with a fact or proposition contained in a question, then the fact or proposition is not evidence simply because it was suggested in the question. You would have to look elsewhere for evidence about that issue. You may not consider any answers that I've stricken. They're not evidence and cannot be used by you as evidence or considered by you for any purpose. The opening statement and closing arguments of the lawyers, not evidence. They're only intended to assist you in understanding the positions of the party. My instructions, anything that I've said during the trial, not evidence. All right, so if your memory of the testimony differs from the attorney's or mine, you are to follow your own recollection. You must consider the evidence as a whole. Now, I want to talk about direct and circumstantial evidence. There are two types of evidence that you may use to determine the facts in this case. There's direct evidence and there's circumstantial evidence. The law allows both direct and circumstantial evidence in a criminal case, and circumstantial evidence alone may be sufficient to establish guilt beyond a reasonable doubt. Direct evidence is when a witness testifies directly about the fact that is sought to be proved based upon what he or she claims to have seen, heard, or felt with their own senses. And the question there is whether you believe that witness or not. Circumstantial evidence is when Circumstantial evidence is when no witness can testify directly about the fact that sought to be proved, but you are presented with evidence of other facts and then asked to draw reasonable inferences from them about the fact that sought to be proved. There are, however, several things you should keep in mind about circumstantial evidence. The first one is that you may draw inferences and conclusions only from facts that have been proved to you beyond a reasonable doubt. The second rule is that any inferences or conclusions you draw must be reasonable and natural based on your common sense and good judgment. In a chain of circumstantial evidence, it's not required that every one of your inferences and conclusions be inevitable, but it is required that each of them be reasonable, and that they all be consistent with one another, and that together they establish the defendant's guilt beyond a reasonable doubt. Inferences must never be based on conjecture, surmise, guesswork, or assumption. And whether the evidence is direct or circumstantial, the Commonwealth must prove the defendant's guilt beyond a reasonable doubt from all of the evidence presented in the case. Now, I want to talk about the credibility of witnesses, all right? It's going to be your duty to decide all the disputed questions of fact. You are going to have to determine which witnesses to believe and how much weight to give their testimony. You should give the testimony of each witness whatever degree of belief and importance that you judge it is fairly entitled to receive. You are the sole judges of the credibility of the witnesses, and if there are any conflicts in the testimony, it's your function to resolve those conflicts and to determine where the truth lies. You may believe everything a witness says or only part of it or none of it at all. If you do not believe a witness's testimony that something happened, of course, your disbelief is not evidence that it did not happen. When you disbelieve a witness, it just means that you have to look elsewhere for credible evidence about that issue. And when deciding whether to believe a witness and how much importance to give a witness's testimony, you must look at all the evidence, drawing on your own common sense and experience of life. Often it may be not what a witness says, but how the witness says it that might give you a clue whether or not to accept that witness's version of an event as believable. You may consider a witness's appearance and demeanor on the witness stand, the frankness or lack of frankness in testifying, whether the testimony is reasonable or unreasonable, probable or improbable. You may take into account how good an opportunity the witness had to observe the facts about which the witness testifies, the degree of intelligence the witness shows, and whether the witness's memory seems accurate. You may also consider any motive that the witness may have for testifying and whether the witness displays any bias in testifying and whether or not the witness has any interest in the outcome of the case. Now, I want to talk a little bit about prior inconsistent statements. when you evaluate the testimony the witness gave here in court, you may consider whether that witness made any earlier statements that differ from or contradict in any way their in-court testimony. That earlier statement is generally admitted into evidence solely for your consideration in evaluating the credibility or believability. If you determine that an earlier statement is different from the way the witness testified in court, you may decide that the witness's credibility or believability is affected adversely, or you may decide that it's not adversely affected, but that is the only purpose for which you may use that earlier statement. You may not consider the earlier statement as evidence or proof of truth of any fact contained in the statement. Now, flip side, I want to talk about prior consistent statements now, all right? The testimony of a witness may be rehabilitated or supported by showing that he or she previously made statements that are consistent with their present testimony. The prior statement is admitted into evidence solely for your consideration in evaluating the credibility of the witness. Should you find the prior statement to be consistent, you may consider the prior statement only in connection with your evaluation of the credence to be given to the witness's present testimony in court. You are not to consider the prior statement as establishing the truth of any facts contained in that statement. Now, I want to talk about the defendant's statements that were made to evaluating psychiatrists or psychologists. You may not consider the defendant's statements made to a psychiatrist or psychologist in their evaluation of the defendant as establishing the truth of any facts contained therein. Those statements cannot be used by you as evidence of premeditation, extreme atrocity, or cruelty, or specific intent to kill. Such statements are admissible only as they relate to the basis of the doctor's opinion of the defendant's mental condition. Now, I want to talk about evidence of post-incident conduct. Now, if you have heard some evidence suggesting the defendant's actions after the killings, I'm not suggesting that these are the facts, because the facts are your exclusive domain. But there is some evidence to that effect, and I mention it here to describe the legal point that's implicated. If the Commonwealth has proven that a defendant did any of these things, you may consider whether such actions indicate feelings or consciousness of guilt by the defendant, and whether in turn such feelings of guilt might tend to show the defendant's actual guilt of the offenses with which he's been charged. You are not, however, required to draw such inferences, and you should not do so unless they appear to be reasonable in light of all the circumstances in this case. If you decide that such inferences are reasonable, it will be up to you to determine how much importance to give them. But you should always remember that there may be numerous reasons why a person not responsible for the crimes charged might do the things attributed to her. Such conduct does not necessarily reflect feelings or consciousness of guilt. So please bear in mind that a person having feelings of guilt is not necessarily guilty. In fact, for such feelings are sometimes found in innocent people. So finally, remember that standing alone, consciousness of guilt evidence, if you find there was any, is never enough by itself to convict a person of a crime. You may not find the defendant guilty on such evidence alone, but you may consider it in your deliberations along with all the other evidence that was presented at the trial. I want to talk next about expert witnesses. Now, there were a number of expert witnesses in this case. This term refers to witnesses who have specialized training or experience in a particular field. Generally, in cases that are tried in our courts, both civil and criminal, witnesses may testify only to facts that are within their own personal knowledge. That is, things they have personally seen or heard or felt. Because a particular witness has specialized training in their field, does not put that witness on a higher level than any other witness, and you are to treat an expert witness just as you would treat any other witness. You may believe all of the expert's testimony, none of it, or anything between those two extremes. There is no requirement for you to believe an expert merely because they are an expert. As with any other witness, It's completely up to you to decide whether you accept the testimony of an expert witness, including the opinions that the witness gave. It's also entirely up to you to decide whether you accept the facts relied on by the expert and decide what conclusions, if any, you draw from the expert's testimony. You must, as has been explained, keep firmly in mind that you alone decide what the facts are. If you conclude that an expert's opinion is not based on the facts as you find those facts to be, then you may reject the testimony and the opinion of the expert in whole or in part. You are also free to reject the testimony and the opinion of an expert witness in whole or in part if you determine that the witness's opinion is not based on sufficient education, experience, or that the testimony of the witness was motivated by some bias or interest in this case. All right. Now, you may have noticed that Ms. Clancy did not testify at this trial. The defendant has an absolute right not to testify, since the entire burden of proof in this case is on the Commonwealth to prove that the defendant is guilty. It is not up to the defendant to prove that she is innocent. Under our system of law, a defendant has a perfect right to say to the Commonwealth, quote, "You have the burden of proving your case against me beyond a reasonable doubt. I do not have to say a word," unquote. The fact that the defendant did not testify has nothing to do with the question of whether she's guilty or not guilty. You are not to draw any adverse inference against the defendant because she did not testify. You are not to consider it in any way or even discuss it in your deliberations. You must determine whether the Commonwealth has proved its case against the defendant based solely on the testimony of the witnesses and the exhibits. Now, speaking of exhibits, now I'm going to talk about that. You will have all the exhibits and the stipulations with you in the jury. If there's a need to play an exhibit or view one, the court will make a computer available for you to use. The things you heard me say we're marking for identification only are not evidence, and you're not going to have those items with you in the jury room because they're not technically part of the evidence. We marked them so we could keep track of them as we went from witness to witness, and there'd be a clear record of some of the rulings I made. So coming back, however, the exhibits that were introduced in evidence, you'll have those with you. You alone will decide the weight that they deserve to receive in helping you make your ultimate judgment about whether the Commonwealth has proven its case. You're not required to believe something simply because it's written on a piece of paper or it appears in a photograph. You're not, of course, required to disbelieve it just because it appears there either. Whether to believe what an exhibit purports to show and how much weight to give the exhibit is entirely up to you to decide. Now, the view. Early in the trial, we drove by some sites and visited an address in Duxbury. As I told you at the time, we referred to that as a view. The purpose of the view was to help you better understand the evidence that you heard during the trial and to help you appreciate the location and its surroundings. The view is part of the case. The observations that you made while on the view may be used and considered in your deliberations in reaching a verdict. Now, I want to talk a little bit about some photographs. The Commonwealth has introduced certain photographs depicting the victims. You'll have those photographs with you during your deliberations. The images depicted are not pleasant. As I instructed you at the time they were introduced, your verdict must not in any way be influenced by the fact that these images are unpleasant or graphic. The defendant is entitled to a verdict based solely on the evidence and not one based on pity or sympathy for the decedents, which might be occasioned by the images depicted. Consider those exhibits only as they may draw attention to a clinical, medical status, or nature of the victim's injuries, the cause of their death, or to the nature of the incident itself. Now, about notes. At the outset of the case, I spoke to you regarding the use of notes, and I want to repeat it this time. Your notes are only an aid to memory and should not be given any precedent over your independent recollection of the facts. Whether you took notes or you didn't, you must rely on your own memory. Do not use your notes to try to persuade your fellow jurors of the accuracy of your reflections, and no juror should be influenced by the notes of other jurors. Your notes are not official or even unofficial transcripts, all right? Now, we'll talk about the use of phones or computers. During your deliberations, you must not communicate with or provide any information to anyone by any means about this case. You may not use any electronic device or media, such as a computer or a phone, to communicate to anyone any information about this case or to conduct any research about this case until I accept your verdict. Kind of want to make that real clear, all right? So if somebody has a question in that jury room, you are not allowed to try and answer it by anything other than through the exhibits and evidence you've heard, all right? We said, so I just kind of want to make that real clear. Nobody used to use a phone to communicate, to try and look. Don't talk to anybody while you're deliberating. Don't try and look up anything, things like that, all right? Just kind of make that as clear as I can. Now, before I go any farther, I have to do one more duty, and that's to select a foreperson of the jury. We have a foreperson for two purposes. The first is to act as your facilitator. That's to gather everyone around the deliberation table to be sure that everyone has a full and fair opportunity to speak and to share their views and to ensure that all of you are always deliberating together as a group as you work to reach the verdict in this case. The second purpose of the foreperson is to act as your spokesperson here in open court. So when you're ready to return your verdict, we'll bring you all back out as a group. We'll ask you to remain standing, and we'll ask the foreperson on everyone's behalf if you've reached a verdict. And if you have, we'll go through the process of having that verdict reported by the foreperson on your behalf, and then it's recorded in the case. All right? So those are the two roles of the foreperson. So in this case, I'm going to appoint in seat 18, juror number 257 as the foreperson of this jury. Okay? Now, members of the jury, if during the course of your deliberations you should have a question about the law or about my instructions on the law, and by telling me this, I'm not suggesting you'll have one, but if you should do the following, all right? You should all first agree on the form of the question, have the foreperson write it down on a piece of paper, and the foreperson should give it to the court officer, who'll bring it to me. I'll call the lawyers together. We'll consider your question and how I should respond to it, and then I'll either bring you back out here in the courtroom and respond to you here in open court with an answer, or if it's appropriate, I might just write the answer down in response to your question and send it back to the jury room. So now that process may cause a lag time between when you ask the question, get it sent out here, and I meet with the lawyers, decide how we answer it, and get the answer back to you. So if you can continue to keep deliberating while waiting for my response, by all means do so. If you cannot go further without my response, then stop and I'll get my response to you as quickly as I can. If it's necessary to communicate with me on any matter during the deliberations, I'd ask you to do so in writing, send me a note and I'll respond to it. You're instructed not to talk to anyone else about any aspect of the merits of this case during your deliberations, and that includes the staff, court officers, lawyers, witnesses, parties, family members, friends, acquaintances, anyone, all right? Now, your communications with the court officers should have to do, really just matters of scheduling and breaks, when you come back to the courtroom, that kind of thing. But even with them, don't discuss what's going on inside that jury room if you can. Now, while you're in the jury room, you should all talk about this case only in the presence of each other. That is, at some point, we'll have lunch brought to you. So if you'd like, you may, as a group, decide to suspend your deliberations, have lunch, and then return to the deliberations. Or you might decide you'd like to work through lunch while deliberating. Either way, the only thing we can't have is some of you eating lunch separate from others while deliberating, all right? So no subcommittees in a sense. What you do as a group, all right? You do it all together. Now I'm going to get to a difficult part, reducing and sending out the jury, all right? When we impanel a jury at the beginning of a trial, we never know whether some personal emergency will arise or during the course of the trial, which would require one or more of the jurors to be excused from further jury duty. To avoid having to start the trial all over again, if that should occur, we impaneled, in this case, 18 jurors, even though the case will be eventually decided by 12 of you. And we made that decision because this was a lengthy case over the summer. The time has now come to reduce that number. This is especially difficult in this case where all 18 of you have been equally dedicated and attentive to this case during the course of this trial, but the case is to be decided by 12, all right? And so the way it's done is the clerk will draw the alternates' names, we put all the numbers, the exclusion of the foreperson, and then we'll draw out the names randomly for the alternates. And the purpose of the alternate, for those of you who are selected, is that even during the course of deliberations, sometimes things happen. You know, one of the deliberating jurors gets sick or a family emergency, and so we may, and it happens fairly regularly, that would have to substitute one of the alternate jurors into the deliberating jurors. Because if we didn't have the alternate jurors still here, we'd have to start all over again. So that's why we do it. It doesn't make it any easier, but I thought I'd just explain to you why we have to do that. As I put in here, fate makes you an alternate juror. Don't take it personally. Your presence to this point and continuing availability, if you should be needed, is an important contribution. The court officers will make you as comfortable as possible while the jury deliberates. If you're an alternate juror, you should not discuss this case with anyone at all while the deliberations are ongoing, nor discuss it among your fellow alternates, as the need might come up that you have to join in the deliberations. So in other words, the alternate jurors can't have their own kind of informal deliberations. And it's very difficult, but I just kind of want to make that clear, that you have to do that, or you cannot do that. So at this point, I'm going to ask the clerk to reduce the jury at this point.
The following jurors are chosen as alternates. Juror number 157 in seat number 11. Juror number 162 in seat number 12. Juror number 385 in seat number 14. Juror number 122 in seat number 6. Juror number 124 in seat number 7. And juror number 245 in seat number 15.
All right, thanks. Now, what I kind of forgotten to talk about, I mentioned it with the foreperson and everyone in regards to the verdict, just the verdict slip. This is the verdict slip. This is what it looks like. There will be a verdict slip for each count, and it says right there's a count regarding Cora Clancy, there's a count regarding Dawson Clancy, and there's a count regarding Callum Clancy. And on each of those, there's a box for not guilty by lack of criminal responsibility, guilty of murder in the first degree by the theory of deliberate premeditation or extreme atrocity and cruelty. There's a box for guilty of murder in the second degree. There's a box for manslaughter. So when you have reached a unanimous verdict as to which verdict it is, the foreperson is to check that box that is applicable to the decision, sign it and date it, and let the court officers know we have a verdict. Okay, so it's pretty self-explanatory, but I just kind of wanted to let you know that. Now, I know I'm not telling you anything you don't know when I tell you that reaching a verdict in this case is not necessarily going to be an easy task. It's going to require conscientious service on your part and a conscientious approach to your duty as jurors. I suggest respectfully that each approach it with mutual respect for the opinions of your fellow jurors. They have a disposition to listen to each other. Don't be afraid to change your own opinion if the discussion persuades you that you should, but don't come to a decision simply because other jurors feel it's the right decision. It's your decision, all right? Each of you must decide this case for yourselves, and you should do so only after you considered all the evidence, discuss it fully with your fellow jurors, and listen to the views of your fellow jurors. You all heard the same evidence. You've all heard it with the same degree of attention. You're all governed by the same desire to arrive at the truth, and you're all under the sanction of the same oath that you took as jurors at the start of this trial when you agreed to well and truly try the issues between the parties in accordance to the evidence and the law. Now, I'm about to submit this case to you, and I need not remind you that you have an awesome responsibility. But I believe that you will bring to bear all the wisdom and the judgment and the conscience that you possess in reaching your verdict in this case. All that we can expect from you is that you decide this case with integrity and with principle. Now, everyone has feelings, assumptions, perceptions, fears, stereotypes. Those are implicit biases that we may not even be aware of. These hidden thoughts can impact what we see and hear, how we remember what we see and hear, and how we make important decisions. Because you're making such an important decision in this case, I strongly encourage you to evaluate the evidence carefully. Resist jumping to conclusions based on personal likes or dislikes, generalizations, gut feelings, prejudices, sympathies, stereotypes, or biases. The law demands that you return a just verdict based solely on the evidence, your individual evaluations of that evidence, your reason and your common sense in these instructions. Our system of justice is counting on you to render a fair decision based on the evidence and not on biases. Please have confidence in what you're about to do, all right? I have that confidence in you. I don't think I've ever seen a more dedicated group of jurors in any trial that I've ever been involved in. You're all people of intelligence and common sense. Collectively, you're bringing a truly powerful force to determine the truth of the matters in this case. And I, as I said, have great confidence with this case in your hands. You're honest, thoughtful, and fair, and be that as you took the oath to be. I am completely confident you'll be able to arrive at a just verdict, whatever that verdict may be. So at this time, I'm going to ask if I could see counsel at sidebar just for a second, and then we'll have the clerks swear in the court officers, and then you'll be sent out to deliberate.
What's up, jerks? Looks like we're waiting for a verdict now. We got zapped today. I don't know if you saw it earlier, but we got whacked today. We were streaming this thing. We were streaming. I want to replay Kevin Reddington from today in the closing arguments, but I don't dare to because YouTube, like I said, during the live stream, they shut it down. We haven't been penalized yet. It's actually there. You can actually watch it, which is weird. Maybe they overruled themselves. I don't know. The content today, I can see why it would get struck. Obviously, we edit though. We edit. This is YouTube, right? We just go. We just say F it. Let's just do it. I mean, this is for 3 kids. That's what this was about today. Whether you find, whether you think she's guilty or not, in the end, this is about 3 kids. Whether you think you go with the crazy conspiracies, which I don't go for, about Patrick, it's about 3 kids. I think we all need to remember that. Like I have the link in the chat. If anyone wants to call in today, this would be a good time to do it. I haven't taken calls in a long time. I was even maybe thinking about setting up the phone number, the old phone number. Maybe do it through Google. Do it the old school way. But I'm not prepared for that. If we get any StreamYard calls, we get them. Great. But we got whacked today while we were streaming this thing earlier. They shut down our live stream. I heard it happened to other streamers as well, but it doesn't look like it happened to the big ones, which is weird. Why do they always pick on the smaller ones? Why do the big ones stay up and we go down? I don't know. We went dark. So we just replayed it. We just replayed the jury instructions. We missed that. We also had a great stream just earlier from with Rosemary Scarpiccio and Adam Lally. If you didn't get to check that out, that was amazing. We just streamed that from Massachusetts courts today. Miles King hearing. Yeah, I heard it happened to Melanie too. I heard Melanie went dark just like us. So there you go. One big channel to get whacked. But like I didn't see Court TV go down. I didn't see ABC and NBC and all the rest of them. I didn't see them go down. But us law tubers, Melanie and myself and maybe some others, we went down. Isn't that weird?
Swear that you will take charge of this jury and keep them in silence.
I'm going to shut up for a second. I'll be back.
Have agreed that you will not speak to them yourselves, nor suffer anyone else to speak to them, except by order of the court, so help you God. As to the alternate jurors, keep your hands raised. Do you solemnly swear that you will take charge of these alternate jurors and keep them in a convenient place, separate and apart from the other members, that you will not speak to them yourselves, nor suffer anyone else to speak to them, except by order of the court, so help you God?
I do.
Thank you.
All right. Members of the jury, you may now retire to consider your verdict. Thank you.
Court, all rise. Jury, let me know what's instruction, call it in.
It was a little earlier today. Maybe about an hour and a half ago. Like I said, we got delayed because I had some dog walks to do. I had the other stream going, and then we got whacked. We had 2 streams going at once, and they whacked our stream. But we're going to be on jury watch here today and maybe this weekend. We'll see. It's in the hands of the jury right now.
I just wanted to make one comment. And it really is, unless you've tried a difficult murder like this one, you may not be aware how difficult and tough it is to try a case like this. It's emotionally taxing. It's intellectually challenging. It's physically exhausting. So I just wanted to commend all 3 counsel for their work and their efforts in this case, in this trial. I know how challenging it's been for them, so I just kind of wanted to acknowledge that and thank them for their efforts in regards in this case. So then before we break, could I see counsel just in regards to a couple of the exhibits?
All rise.
Do each of you solemnly swear that you will take charge of this jury and keep them in some convenient place until they have agreed? That you will not speak to them yourselves, nor suffer anyone else to speak to them, except by order of the court, so help you God? As to the alternate jurors, keep your hands raised. Do you solemnly swear that you will take charge of these alternate jurors and keep them in a convenient place, separate and apart from the other members? That you will not speak to them yourselves, nor suffer anyone else to speak to them, except by order of the court, so help you God? Thank you.
All right. Members of the jury, you may now retire to consider your verdict. Thank you.
Court, all rise. Jury, let me know folks. Instruction, followation.
Jurors have exited the courtroom.
All right, everybody can be seated. I just wanted to make one comment. And it really is, unless you've tried a difficult murder like this one, you may not be aware how difficult and tough it is to try a case like this. It's emotionally taxing, it's intellectually challenging, it's physically exhausting. So I just wanted to commend all three counsel for their work and their efforts in this case, in this trial. I know how challenging it's been for them, so I just kind of wanted to acknowledge that and thank them for their efforts in regards in this case. So then before we break, could I see counsel just in regards to a couple of the exhibits?
So we're all caught up now. We're all caught up. We heard the full jury instructions. We saw the closing arguments today. And now they're in deliberations. We're waiting. We are waiting now. We're just going to wait. I guess we're just going to keep this up. I do have a couple errands to do. I'm also going to be streaming the Tupac hearing today. It should be good because going to have some defense witnesses, maybe some hostile police. This might get good today. It's only a couple witnesses, apparently. That's a disappointing thing. I don't think Keefe D. Dwayne Davis is putting up much of a defense. And I think it's because they feel like there's not enough evidence against him. The only evidence they really have is his words, right? We'll see. We'll see what this jury decides. There'll be 2 juries we're going to be waiting on this week. Probably, I don't know. How quickly do you think Clancy's going to come back? No, I haven't got myself any lunch yet. I haven't. I got a 4 p.m. or between 4 and 4:30 dog walk to do with a customer, and I do need to get some lunch. I'm not sure. I might just go food shopping too. The pantries are getting empty, so I might just hit the local supermarket, or I could just do takeout again. We'll see. I do need lunch. I'm getting hungry. We've been working all day. I've been doing dog walks and streams, and it's our 3rd stream of the day. We're going to do a 4th one later on Tupac later tonight. And I got some shows booked this weekend already too, so we're gonna be hitting a lot of different topics on the channel, regardless of numbers. We don't care about whether we get the big numbers or not. Some days we get it for the court streams anyway, so who cares, right? We're just booking interviews that I'm interested in now, which I like. And if you haven't checked out that Dave Wedge interview, check it out. People really seem to enjoy it. I got a lot of good feedback, a lot of replays. A lot more people are watching on replay than even live, so that's always a good sign. Yeah, the jury is deliberating right now. Absolutely. They're probably going over everything. They're probably not even actually deliberating. They're probably more reviewing right now. That's usually what most juries do. Usually they spend a whole full day reviewing, unless they know right away that they've already made up their minds. Sometimes they might do an early vote just to kind of poll to see where everyone's feeling. But a lot of times, especially in a murder trial, especially this case, I think, they're probably going to spend a full day at least just reviewing it, just going through everything, if not even longer. So I would not expect a jury to come back today, but it's definitely possible. It does happen. Sometimes you see a jury come back after an hour or two and just come back and say not guilty. End of story. We're all going home. So it could happen today. I mean, we're waiting. That would be, if you see a jury come back today, that's a very good sign for Clancy. That's a very good sign for the defense. But I have a feeling we might not see anything until Friday or Monday or Tuesday. I bet Tuesday. You know, I bet they, I don't know, we'll see. We'll see how long this takes. Is it going to be a hung jury? I don't know. I just don't know. This is a tough one. And again, we do have the StreamYard link. I know a lot of people get shy about the StreamYard links, and they, especially the video aspect and not knowing how it works. You don't actually have to turn on the video. You can just do an audio call if anyone wants to weigh in today. But again, I'm not going to hang out here too long. Like I said, I do need lunch. I'm going to go get something to eat. I just figured I would check in, say hi, and offer. If you have any questions for me, you have any questions about anything, maybe I can respond to the clown. The clown commented about the fundraisers because I had made a post about it. He was very happy. You know, and he wanted to blame like 1, 2, 3 people for it. There's many more people than that, bro. Nobody wants to deal with your bullshit. I mean, that's not our fault. You know, we had a lot of VIP guests from the family of Karen Reed, as well as some of our bigger media friends. We didn't want to continue to ask them to get clobbered fundraiser after fundraiser. And I think sometimes when you're dealing with things like that we were dealing with those 3 fundraisers in a row for Karen Reed, sometimes the squeeze isn't worth. Sometimes the juice isn't worth the squeeze, I guess the term is. And I think that applies for Karen too. Like, you know, how much more drama do we want to bring to Karen doing a fundraiser? That's not our fault. That's the person who created the drama. So that's the only thing I'm going to say about the drama queen who talked about us on a show yesterday morning, I guess. I don't know what he did today. I don't keep up with him. I don't even watch it, actually. If it comes back quick, I'd imagine it's a guilty verdict. There's almost no way it's straight not guilty. Eric Mulholland. If it comes back quick, I imagine. You know what? You kind of have a point. I mean, usually you would think not guilty. Usually that's like the prosecution didn't make their case. you may have a point on this one. This might be different. You're right. You know, normally you would think a quick verdict means the state didn't meet their burden. The jury didn't really have to think about it. They just said, you know what? They didn't have enough evidence. That's what you see a lot. But you're right on this one. There's a lot of evidence she did it, but it's whether or not you believe she's legally, you know, she's legally all there, right? So I don't know. It's a good point. I have a feeling this could be a hung jury. This is a classic hung jury. Because if you look at online, and that's the thing, we're going by online too, like 70, 80%, it seems like, think not guilty on this, which is wild. It's crazy. Never seen anything like that for something like this. 3 children. You see numbers like that, you start to think maybe it would be a not guilty, but I still see like that 20, 30% who say she's guilty. They're very strong in their beliefs. They can't get over the 3 children. So I could see this totally being a hung jury. But you never know. And I think the crowds do affect the juries now. I really do. I do think the crowds affect the juries. I think it's going to be a hung jury. We'll see. We'll see. Yeah, that's the question. That's the real question. Was she sane when she did it or not? I don't know. What do I think? Jeez. I mean, generally, I want to give the benefit to the defense because I think a lot of people they have rights, and I think there's a lot of times there's a rush for justice. But I can't get over those 3 kids, you know, and the fact she did one after another, you know, it just I don't know. I would probably say not guilty because that's just the way I'm built. Because I can't really know, but on the other hand, it would be hard to say not guilty. I might say guilty. I don't know. Because of this specific crime, too, like the way it was done. It did seem planned. And that's the thing. That's why I still think she could be found guilty. If she has the right jury for it, it could be a guilty. You never know. Because of the specifics of what went down here. I think it would be different if it was one child. You know, but having 3 children in a row, that's where you kind of get caught up. You're like, was this planned? And it was the same way, all 3, right? The exercise bands. It'd be one thing if it was like just random. You'd think that's where my mind starts thinking about logic. But when people are crazy, there is no logic. So I don't know. I really don't know. And I don't think people should be so sure on it. Like on both sides, people are so sure. What I appreciate is the ones that focus on the 3 children. I think that's what the main thing I should be doing. It's just we should talk more about the 3 children. Because that's the real tragedy here. And it doesn't matter what the jury decides in the end. Those 3 kids aren't coming back. Their lives were taken away, and I can't imagine the horror for them from their own mom. It must have been freaking so scary. And one of them was just a baby. And we've recently had a baby in our family too, and it's like they know what's going on even as babies. It's wild when you really I don't know what's worse, like the youngest or the oldest. It was just all of them. This is a tough trial. This was a tough trial. The cover, I'm glad it's over. Honestly, it was getting us views, which is good for us. And generally, you don't want that to end. But this was like, I want this over. And I just hope people, no matter what happens here, I hope the people outside and the people who have picked up sides just keep it together. Don't make it about you. Don't make any drama. If you're gonna pay tribute to anything, pay tribute to those babies. Make it about the kids. Yeah, I get that. I mean, that's obvious, Peggy. The focus isn't on the kids in this trial. It's about the mother's mental state when she did kill those kids. But I'm not the court. You know what I mean? I'm in the media. I'm in the media realm, and we're in the human being realm, and we can focus on those kids. Like, you know, it'd be different if I was a jury member or an attorney or I was a probation officer in the court. I'm not. I'm in the media. I'm sitting at home. I can talk about the kids. And obviously I do think one of the best things about this trial was mental health got brought up a lot, especially with women, postpartum, anxiety, bipolar, psychosis. There's much more awareness, and also the reality that it affects so many people. I think that's one of the things that came out with this trial, the positives on this. If you have to say there was something positive about this, that's what you would go to, and you would hope maybe that's why those 3 babies had to go, is just to wake everyone up to say, hey, you know what? We got to take this stuff much more seriously, even within the doctors and the healthcare. They deal with this every day. They know how serious it is. But again, I think they're going to be on their P's and Q's now, thinking like, is this person having issues with their medication? Could they be the next Clancy? Do you have any children? You know what I mean? Maybe they'll focus on that a little more with the moms, especially. It's Peggy. It was a good, I'm glad you brought it up. I think you supported us today, right? Was that right? You didn't you make a donation on the other stream too? I appreciate you, Peggy. No apologies needed. This is you didn't call me a name or anything. You're very nice here. This is a good discussion. Um, the kind of oracle says the only man in that courtroom that had a sliver of understanding of a woman's mental health and postpartum depression was Red. I mean, I don't know. I think the judge probably has an understanding of it now, a little bit at least. I like this judge. I thought he did a pretty good job. And I don't know who else was in the courtroom. So I don't like to rule. I don't like to be, absolute about things. Who knows? Yeah, Lillian, I don't go with this because you know what? Reddington is a great lawyer, and they didn't make any of that defense. They didn't even allude to it. They didn't even try, even in the pretrial hearings. Usually, if that's even an inkling, they'll at least try. They'll at least try to. There's none of that. I just don't buy it. I don't buy that he had anything to do with it. And she's not denying she did it. Yeah, I think that's the big thing, Allie. Hopefully, there's more attention on this. Well, we'll see. I don't have any calls. So, you know what? I think from the audience, too, from you reminding me I haven't eaten lunch. It's time to eat lunch. It's time not to do so much. I did a lot already this week. I got Grace Curley tomorrow. I'll be on Grace Curley tomorrow, probably talking about this at 1:05 p.m. We'll be airing the Tupac hearings later today, the Tupac murder trial. It's either it starts at 3 or 4 p.m. Eastern time. I'm not sure. We'll figure that out. But again, I'm just going to leave this up for now, just in case they come back, especially while I'm food shopping. I don't want to miss it. I'll have it on. I'll have my phone. This is what I do. I walk around with the phone, just giving me the alert. I'll be checking out the chat. Yeah. Yeah, exactly, Peggy. 100%. All right. We still got a good number watching on Facebook, on Twitch, on YouTube we're on as well, and X, quite a few on X as well. We used to be on LinkedIn, but LinkedIn's been giving me some trouble. I got to figure that out again. But Twitch, I'm seeing people watching us on Twitch lately, which is wild. And Facebook's been doing really well for us. Thank you, all the Facebook people. Make sure you like and subscribe. I know a lot of new Facebook followers. I think over 1,000 this month alone. Thank you to all the Facebook people. Our Young Jerks Facebook page. And also Twitter, starting to get some new followers over there. Thank you so much. And YouTube, we picked up a couple hundred. So thank you, everyone who's a new subscriber. If you're in the chat, thank all the new subscribers on the way out. Give yourself a 1 for sticking through this whole trial. And let's go eat lunch, everybody. And hopefully maybe it'll be a verdict at the end of the day. That would be something to see. Or tomorrow. We'll wait till tomorrow, maybe. We'll see. It is time to go eat. I want to thank all of our moderators, to all our mod team. The ladies in the chat, they've done phenomenal. The last couple of weeks, there's been a lot to deal with, both through some of the content here, as well as some of the a little drama, like in some of the trolls. So I want to thank our mod team. They do a really good job here. Not easy. It's not easy to be live and not know what to do, and they roll with the punches. They've done a really good job, and they keep the chat positive. And I really appreciate our mod team. I want to thank our mod team today as well. I want to thank everybody who's been kicking in and donating, especially on the super chats and all of that. Very much appreciate. I think we're all caught up. Are we all caught up? I think we're all caught up. Thank you, Oxymoron. Good to see you today. All right, we're just going to keep this stream going. We'll see what happens. If any updates come, we'll be here, and I'll come back. Either way, I'll try to wrap it up later, but we're going to be covering Tupac as well today, the Tupac trial. Dwayne, Keefe D. Davis going to be back on trial today. He's going to have the first defense witnesses. We're hearing maybe some hostile cops. This could be good today. Tupac, you got to check it out. There's a lot of corruption around this Tupac case, and I think it doesn't get enough attention. People should definitely check out that trial. All right, I'll see you a little later. Peace out. God damn, my man, Lucas. You knows I got the good stuff. I'm almost out though. I gotta hit my guy.
All right. What we're going to do is I'm going to bring the jury back and just excuse them till tomorrow morning. Okay? All right. Yeah.
Court, all rise, jurors entering. This court's now in session, be seated.
Your Honor, present before the court, we have 12 deliberating jurors and 6 alternates in the matter of Commonwealth versus Lindsay Clancy. All other parties are present.
All right. Thank you, Madam Clerk.
You're welcome.
What I wanted to bring you in, it's been a long day for everyone. And so what I'm going to do is excuse all of you till tomorrow morning, 9 o'clock. I just want to, as you can imagine, want to reiterate those instructions. Now you are either deliberating jurors or alternates, possibly to deliberate. So I can't stress it even more than I have for the last 5 weeks. Don't read anything about this case. Don't talk about this case with anyone, even at home. Don't listen to anything. Just put this out of your head. Come back here tomorrow morning. We'll start at 9 o'clock. What'll happen is we'll have you come in. I'll bring you in. I'll ask you those questions. I'll just turn you right around and have you back deliberating. All right? And so with that, with my thanks to everyone, excuse you till tomorrow morning. Thank you.
Court, all rise.
Jurors have exited the quorum. This court's in session.
All right.
Please be seated.
Anything we need to address before tomorrow? Council. Thank you, everyone. We'll be in recess till tomorrow. Thank you.
Court, all rise.
All right. So before we begin the impanelment, I know that there was a motion to eliminate filed by the Commonwealth last week, and it was to, and it's pleading number 129, Commonwealth's motion eliminate to exclude defendants' undisclosed expert witnesses. So I've had an opportunity to review Commonwealth's motion in the attachments. I've had a chance to review the defendant's opposition. And so why don't I hear first from the Commonwealth, and then I'll hear from the defendant. Commonwealth?
Thank you, Your Honor. The Commonwealth's moving for the court to exclude the 4 expert witnesses detailed in the July 7th witness list defense counsel provided to the Commonwealth, or in the alternative to continue the trial so that we can prepare for those witnesses. We received that witness list on July 7th. There were many nurses and doctors on that witness list, many of whom have worked with the defendant in the past. So we weren't clear as to whether the doctors were people she had worked with in the past or if they were experts that we weren't aware of. So we emailed defense counsel asking for information about these experts or these doctors, and he responded pretty quickly. I know in his memo, he says that they're not experts, but they're clearly experts. They're not fact witnesses. It doesn't appear that they knew her, worked with her, observed any of the events leading to these charges. The subject matters that the defense lays out in his notice and in his memo are subject matters that lay witnesses would not be allowed to testify about. Things like mechanism of injury, mental health, medications that are prescribed and the effects of those medications, and psychiatric standards of care, all of which would be expert witnesses. Now, defense counsel is an experienced attorney who understands the rules, and by providing these names at this last minute, a week and a half before trial, was a strategic and intentional act to surprise us with these witnesses and not allow us to be prepared for them. We have a right to prepare for witnesses, to obtain materials, especially with expert witnesses, to find out where have they testified before, what publications have they written, what is the basis of their expertise, and to get rebuttal evidence and or witnesses to be prepared for trial. If the Commonwealth had attempted to do the same at this last minute and bring up expert witnesses, they would be excluded without question. And I know the standard is different for prosecutors, but we all still have to follow Rule 14. And to allow defense counsel to call these experts would be fundamentally unfair to the Commonwealth.
All right. Yeah, Mr. Reddington.
First of all, I can't remember the last time the government, let alone defense, was excluded from presenting testimony by way of, quote, experts, end quote. Generally, it's a matter of fairness. What are they going to testify to? Does the government, in this case, they've got like 39 people working on this case, Judge. And to suggest that they need time to prepare for cross-examination of fundamental witnesses that depend on the direction of their case. For example, I have an emergency room doctor. He's a board certified emergency room doctor that I consult with to help me understand and interpret the medical records, the extensive medical records. South Shore Hospital dealing with the initial admission and the injuries. Brigham and Women's Hospital, she coded on this fake suicide. She coded and almost, and literally her heart stopped at Brigham and Women's Hospital. I need to know terms that I don't understand that this Dr. Velkovich is going to assist me with and has been assisting me with them. Now, I don't know what the government is going to say in their opening statement. So I can stand here right now and tell you, in all likelihood, I wouldn't call Dr. Velkovich as a witness in this case, but it depends on what they say in their opening statement. In the event that after their opening statement, there are issues in play that I feel I would be calling the doctor, I certainly would supplement. And they've already got all their CVs. I've already given them the CVs. As it relates to the psychiatrists, I've given them the CVs. I've given them voluntarily videotapes of their interview and evaluation of Lindsay. I have given them their notes. They've got every scrap of paper that my doctors, that would be Dr. Zeisel, Dr. Resnick, and Dr. Spinelli have. As it relates to, for example, the other doctor that's referenced in the defense disclosure to the government, Dr. Condi. Dr. Condi is not one of my experts. Dr. Condi is an individual who filed an affidavit dealing with the atrocious failure to have medical care that is consistent with the standard that is applicable, and that's in the civil suit. I summons them.